I have watched a daughter stand at a hospital nurse's station with a power of attorney in her hand and get told she could not make a single decision for her father. The document was real, it was signed, it was notarized, and it was useless that day in the hallway because of one word in the wrong place. I'm going to tell you about that word. I'm going to tell you about the 4 documents your parents need before anything goes wrong. And I'm going to tell you what almost every family gets wrong about power of attorney, because I've seen it more times than I can count. Quick thing first. I'm Ryan. I'm a real estate consumer protection advisor and a licensed realtor in North Carolina. I'm not an attorney. I am not a financial advisor. Nothing in this video is legal advice. The laws around power of attorney are different in every single state, and they change. What I'm giving you is a framework so you know what to ask your own attorney. Please do not skip that step. Most families wait too long to set up power of attorney. By the time they think they need it, they cannot get it. Because here's the thing nobody tells you. Your parent has to be of sound mind to sign one. The minute they are not, you are not getting power of attorney. You're getting a guardianship case in court. That can take months. It can cost thousands. And in the meantime, nobody can pay their bills, sell their house, or talk to their doctor. So this video is about doing it before you need it, not after. There's no such thing as a power of attorney. There are 4 separate documents, and a complete set has all of them. If you only get one, you only solved a quarter of the problem. 1. Durable financial power of attorney. This is the one that lets a person you trust handle money, pay bills, sign on accounts, deal with the IRS, sell property. The word durable is the important part. Durable means it stays in effect even if your parent becomes incapacitated. A regular power of attorney ends the moment they cannot make decisions. That is the opposite of what you need. 2. Healthcare power of attorney, sometimes called a healthcare proxy or a medical power of attorney. This names one person who can make medical decisions when your parent cannot speak for themselves. Different document, different signature. Doctors will not accept the financial one for medical cause, period. 3. HIPAA release. This is the one almost everybody forgets. HIPAA is the federal law that protects medical privacy. Without a signed HIPAA release, a hospital does not have to tell you anything. Not your parents' diagnosis, not their medication list, not whether they are even in the building. The healthcare power of attorney usually grants access too, but a separate HIPAA release is cleaner and faster, and it can name more than one person. According to the Federal Department of Health and Human Services, having a healthcare power of attorney does give the agent access to records, but a separate HIPAA authorization can name additional family members so multiple kids can talk to the doctor without arguing about who is in charge. 4. A living will, also called an advance directive. This is the one that says what your parent wants and does not want at the end of their life. Feeding tubes, ventilators, resuscitation. This is not about handing over power. It is about telling everybody what your parent already decided in writing when they were healthy enough to think about it. It takes the weight off the family. 4 documents together, not 1, 4. Now here's the part that costs families the most. You ready? There are 2 flavors of durable power of attorney, immediate and springing. An immediate durable power of attorney is effective the second the ink dries. Your parent signs it Tuesday, you can use it Wednesday. The trust is built into who they choose, not into when the document turns on. A springing power of attorney does not turn on right away. It springs into effect only when something specific happens. Usually, that something is a doctor declaring your parent incapacitated. Sounds reasonable, right? Sounds like extra protection. Here's what happens in the real world. Your dad has a stroke on a Saturday. You drive to the hospital. You have his springing power of attorney in your bag. You hand it to the bank on Monday morning to pay his mortgage so the house does not go into default. The bank says, we need certification of incapacity. Cool. You call the doctor. Doctor says, we don't write that letter. Talk to neurology. Neurology says, we need to evaluate him after he is stabilized. The hospital says, insurance is making us discharge him in 2 days. And now you are 3 weeks deep in a paperwork tangle while your dad's house is heading to a missed payment. I have seen this more than once. The springing language is what created the gap. For most families, an immediate, durable power of attorney signed by someone you trust is the safer choice. Some attorneys disagree. Some states make it harder. Florida, for example, does not even recognize springing financial powers of attorney that were created after October 1st, 2011. If you signed one in Florida after that date, it does not work the way you think it works. That is one state. Other states have their own rules. Talk to an attorney in your state. I cannot say that enough. Now let's say you did everything right. You have a durable, immediate, beautifully drafted financial power of attorney. You walk into your parents' bank to pay their bills. The bank says, "We can't accept this." This happens all the time. AARP has a whole article about it. Here's why. Reason 1, the document is too old. Banks get nervous about a power of attorney signed 20 years ago because they do not know if the agent named on it is still the agent your parent wants. There is no expiration date on a power of attorney in most states, but banks treat one over 5 years old like it might be. Reason 2, the bank wants its own form. A lot of banks have an internal power of attorney form that they prefer. They can ask you to fill it out. They cannot legally require it as the only form they accept in most states, but they will try. If your parent is still mentally sharp, the easiest move is to walk in together while you can and fill out the bank's form right then. Reason 3, vague language. Some power of attorneys say things like all financial matters. That is sometimes not specific enough. Some banks wanted to say the right to access account number such and such, or the right to sell real property. If your attorney drafts a power of attorney, ask them to make it specific. Reason 4, fraud paranoia. And to be fair, some of this is appropriate. Banks see elder financial abuse every single day. They're nervous. They've been sued, so they push back hard. What do you do if the bank rejects it? You don't yell. You ask for the legal department. You ask in writing what they need to honor it. In most states, if the bank wrongfully refuses a valid power of attorney, the agent can take legal action. But that is a year of fighting. The cleaner path is to do it right up front and walk into the bank with your parent before there is an emergency. Everything I've just said varies by state. Power of attorney is not a federal thing. Every state has its own rules. There is something called Uniform Power of Attorney Act, which is a model law that 32 states plus DC have adopted. In those states, the rules are pretty consistent. If you live in a state that adopted it, your power of attorney is more likely to be honored across state lines. If your parent retired to Florida and you live in North Carolina, that matters. The other states have their own statutes. Some of them are very different. Florida, like I said, does not allow springing power of attorneys created after 2011. Some states require 2 witnesses plus a notary. Some states have specific language that has to appear in the document or the bank will not honor it. Some states make a healthcare power of attorney more powerful than others. I cannot tell you what your state requires. I can tell you to ask. The National Academy of Elder Law Attorneys is the place to start if you do not have an attorney already. I am a realtor, not a lawyer. I am telling you what I have watched go wrong, not what to file. Okay, construction and investor guy mode. Here's the plan. Week 1, have the conversation with your parent. Use the line, I want to make sure if anything ever happens, the people you trust can act fast and the people you do not trust cannot. That is the framing that works. Write down who they want as their financial agent, who they want as their healthcare agent, and who their backup is for each. Week 2, find an elder law attorney in your parent's state, not your state, theirs, where they live and where their property is. Use the National Academy of Elder Law Attorneys. Initial consultations are usually $100 to $300. The full document set runs anywhere from $500 to $2,000 depending on where you live. That is cheap insurance against a guardianship case that costs 10 times that. Week 3, sign the documents, all 4, with witnesses, with a notary. Make at least 4 originals. Yes, originals, with wet ink signatures, because a lot of banks and hospitals will not accept copies. One stays with your parent, one stays with the agent, one goes in the document vault, like the one inside Senior Safe, so the family can find it under stress. One stays at the attorney's office. Week 4. Walk into your parent's bank with the new financial power of attorney. While your parent is still able to walk in with you, have them introduce you, sign the bank's form, and put the power of attorney on file. Same thing with the healthcare power of attorney at the doctor's office and the hospital system they normally use. You are pre-clearing the document, so when you actually need it, nobody has to look it up. That's it. 4 weeks, done. You will sleep better, and so will your parent. I do not get paid when you set up a power of attorney. Nobody pays me on the back end of this advice. I'm telling you because I've watched families lose months and tens of thousands of dollars to a missing piece of paper. Do not be that family. If you want a free starter guide that walks you through all of this and the rest of the senior transition checklist, the link is in the description. It is called the Simple Blueprint. It's free. And if you want a place to actually store those documents so the whole family can find them under stress, that is what I built Senior Safe for. It is live as a web app right now. 2 weeks of premium are free for everybody. Link is in the description. Talk to an attorney. Get the 4 documents. Do it before you need to. That's the whole video.